Welcome, everybody. Thank you for joining us for the release of a fascinating new study. The name of the study, Closing the Gap, Evaluating Rapid Response Labor Mechanism Outcomes and Charting a Path through the 2026 USMCA Review, sums up the findings of what is the first comprehensive review of the 37 US-Mexico-Canada Agreement Rapid Response Labor Rights Enforcement Mechanism cases in the first 5 years of the pact. Measuring the success of the RRM has implications beyond just North America. Having a facility-specific, powerful labor rights enforcement mechanism in the revised NAFTA was a first ever of any trade agreement, so it set a new model. The good news, the analysis of the cases proves effective enforcement of labor rights in a trade agreement can and did deliver real gains for workers. Tens of thousands of workers won independent unions who negotiated collective bargaining agreements that got accepted and raised their wages. But over time, the gains have diminished. The methodology of this study includes coding each of the cases for various procedural and outcome factors. So we're able to actually trace the outcomes over time. The research and the years of litigation experience on behalf of workers using the RRM by my colleague, Danielle Rangel, our research director at Rethink Trade, who is the lead author of the study and will present the paper, that has allowed us to identify improvements necessary for the RRM to continue to bolster workers' rights across North America. These improvements must be made during the mandatory 6-year USMCA review that got launched last week. So without further ado, it is my honor to introduce Danielle Rangel, the research director of Rethink Trade, lead author, litigator on quite a few RRM cases, and I might add, a graduate of the LLM program of Georgetown University Law School. He was already a trade lawyer practicing in his home country of Colombia. He also has a master's in economics from Sciences Po. Danielle, please let us know what you found with this amazing research.
Thank you, Lori. Thank you all for joining us today. I'm gonna share my screen so that people can see and presentation. Give me 1 sec. Okay, so our report is called Closing the Gap because we see that there are several gaps in the implementation of the USMCA and the RRM as such. So we wanted to explore all of the developments that we have seen over the past 5 years, in which we have had this very path-breaking rapid response mechanism, and start developing some conclusions that could inform the 2026 review, which just started, as Lori mentioned. Just to cover the basics for everyone who might not be super familiar with this mechanism, I want to start by highlighting first, this is the first of its kind corporate accountability tool that has been included in a trade agreement. We call it a corporate accountability tool because it allows investigations on individual facilities, that is, workplaces where workers are denied the rights to freedom of association and collective bargaining. So the USMCA labor chapter has other labor rights that are protected, but this specific mechanism only protects these two rights. And it covers virtually every sector in the economy but agriculture. So even though the rights scope is limited in terms of like coverage of the economy, is quite expansive, and also it has a requirement that has been called like the trade nexus. Basically, the facilities have to either export or compete with foreign products in order for them to be covered by the mechanism. It's also novel because the sanctions are imposed at the company level in an escalating system that starts potentially with applying tariffs to the goods that are produced at a specific facility or the services that come from a specific facility, to even the denial of entry of those goods to export markets. So it really has some teeth. And that was one of the reasons why companies have really paid attention when they face one of these cases. And the underlying context in which this system appeared is the undeniable decades of wage suppression in Mexico that have contributed to a race to the bottom in North America. For people who are not as familiar with the labor relations in Mexico, there is a widespread problem of what it's called protection unions. These are basically unions that, instead of representing workers, they represent the interest of employers. And by 2020, Mexican authorities estimated that around 80 to 85% of all of the collective bargaining agreements that existed in Mexico were protection contracts. So contracts that benefited the employer, that in many cases the workers didn't know that covered their workplaces, and certainly they didn't vote for them. So with the RRM, the USMCA also obligates Mexico to reform its labor laws and institutions. And I would say that that's also something that had been demanded by certain labor unions in Mexico, certain parts of the political society in Mexico for decades. So in 2019, there is this great opportunity for everything to come together to have this kind of system at the supranational level, but also a new labor reform and new labor institutions in Mexico that actually gave opportunities for independent unions to fight against some of these entrenched protection unions that were not properly representing workers. Before going into some of our findings, I want to quickly walk you through what is like the ideal process of an RRM case. And I'm basically focusing my presentation on the US-Mexico system. There is an identical annex for Canada and Mexico that has not been widely used. So our study, our report focuses on the US-Mexico system. First, it starts with a petition that can be filed basically by anyone before the Department of Labor, and that gives the US government, that is Department of Labor and the US Trade Representative Office, 30 days to investigate the complaints. If at the end of the 30 days they determine that there's a good faith belief that there has been a denial of rights at the specific facility, they will ask Mexico to conduct its own review, and Mexico will have 45 days to do so. Mexico can agree with the US and say there are problems of compliance at this facility, and then both governments come together and they negotiate a remediation plan that's formally called a course of remediation. But if Mexico says that there are no problems of freedom of association and collective bargaining at this facility, then the US government has the right to go to a panel, and that's a group of 3 labor experts who will determine if there were violations or not, and they will authorize sanctions. The sanctions, as I said, will be tariffs first, even fines or penalties on the goods and services produced by that facility or by that group of companies. And eventually it could lead, if a company has 3 strikes, that is 3 courses of remediation or 3 negative determinations by a panel, to the denial of entry of their goods to the export market. So, considering that that's the way in which it was designed to work, one of the things that was interesting when we started analyzing the different cases was the green portion of the cases that you see here. So, but let's start. There have been 37 cases launched by June of 2025. Now I think that we're in 39, but that's where our closeout date for the study. So of those 37 cases, 32 had concluded the pre-panel phase by the date, or by the end of June of 2025. 8 of them ended with that formal course of remediation, that agreement between the two governments that determines that there were violations and that there are certain actions that need to be taken in order to fix the situation. 6 of these cases went to panels, and of those, there are already 2 panel reports. 2 had other type of outcomes, and basically these are cases in which the US negotiated directly with the company instead of negotiating with Mexico. But 16 of the cases were considered resolved during review. And that's the situation in which the US asked Mexico to review the situation because they found that there was evidence of a denial of rights. And during the 45 days that Mexico had to investigate, the company carried out certain actions. And then Mexico concluded that if there were violations, they were resolved during review. This is problematic because the agreement doesn't really contemplate what are the consequences of a case being resolved during review, whether it counts as a strike in the escalating penalty system that the agreement has. So dealing with this issue is very important because it could be allowing the company to keep its record clean, despite the fact being involved in credible allegations of denial of rights of freedom of association and collective bargaining. Now let's turn to the substantive outcomes of these cases. What we did here is that we basically classified all of the different categories, all of the different remedies that were achieved either through a course of remediation or those that were considered to determine that the case was closed during review or was remediated during review. And we came up with this top 10 of most common remediation actions. And here, what I would like to highlight to begin with is that in 19 cases, that is 2/3 of the cases, workers who were fired for their union activity or the union preferences were reinstated and provided back pay. That is a key development because that really supports workers' rights and workers' ability to fight for their rights. So we think that that has been a very positive development. But also there are certain remedies that over time we have started to notice that don't have the same kind of positive consequences. For instance, the neutrality statement and zero tolerance policy that we see there, they have been included in pretty much every case that did not go to a panel. And that's basically a statement by the company that that it will not interfere with workers' rights and freedom of association liberties. And the zero tolerance policy is an internal policy of the company that management is to abide by the neutrality statement. The issue is that, as was shown by the Atento Servicios panel report, which was one of the 2 cases that had been already decided, in that case, the company had adopted a neutrality statement and a zero tolerance policy, but that did not lead to the stop of union busting behavior. And that was a conclusion of the panel that in a way should lead to stronger remedies in cases that have been that could be decided after this one. Lastly, I will also highlight that there are 2 remedies that are very important for the objectives of actually strengthening union representation and collective bargaining, union access to the facility that only happened in 7 cases, and the obligation on the company to recognize and bargain with the petitioning union that only happened in 5 of the cases. So we would like to see more of that, and some of our recommendations are directed towards that. The lack of the lack of cases that had those kind of remediations could be related to what we see in this graph. Here, basically, based on the public information that we had about the cases and conversations that we had with people involved, we classified all of them in 3 different buckets. The first bucket were the cases that where workers gain union representation are a new or a revised collective bargaining agreement after filing an RRM case. The second bucket is cases where there was only new union representation. And the third one was when filing an RRM case didn't lead to any of these outcomes. And what you can see is, and the dates there is the date when the case was started. So the cases that started in 2021 and 2022 all of them led to the outcomes that we will consider will be the most transformational ones. New union, new contract, that's what we want. But as we go to 2023 and 2024, more cases are classified in that third bucket. And one thing to note is that the cases that you see that are marked with an asterisk, that means that in those cases, potentially the violations were not related to a struggle to gain a new union. For instance, the Volkswagen case is related to a Puebla plant where an independent union has represented that plant since the 70s. So those were different issues, but those are a minority of the cases. The majority of the cases, there was really a struggle by a minority union, if you will, to try to gain representation and negotiate a new contract, and that has not happened as frequently in recent years. Of course, achieving those results doesn't depend exclusively on the outcomes of an RRM case, but we do believe that there are changes that could be made to the system that will align better the incentives to have better outcomes in terms of representation and bargaining. And finally, regarding our findings, I'm going to go through this very quickly. There's no public information about the total number of petitions that have been filed under the RRM. So we filed a Freedom of Information Act request, a FOIA request. And in that way, we discovered that 56 petitions were filed during the first 5 years of the RRM. And that led to the 38 cases that we have been discussing. 38 because there's a case in which we were petitioners, so that's different with the 37 that we had before. But one of the petitions was withdrawn, but the ultimate conclusion here is that there are 19 petitions that were rejected and did not trigger the activation of the mechanisms, and there's no public information about why. And also, when one of these petitions is rejected, the petitioners don't get a written decision explaining the reasons why the case did not move forward. And that has problems for petitioners that want to fine-tune the legal strategies to improve the expectations that they want to file, but also prevents public accountability on the activities of the government. And let me quickly go through some of the recommendations that we have in the report. The first one is shorten the response party period for internal review. As I said, right now, Mexico has 45 days. It should be 30. The US practice shows that it's possible to do these investigations in 30 days, and that might help not having as many cases resolved during review and still have like the more holistic approach of having like a formal course of remediation. Second, this is related to how the mechanism is implemented in US law, but basically there is a deadline of 60 days that makes that the US government has to determine whether to invoke a panel 60 days after it has activated the mechanism. We are concerned that that could be forcing the government to forego the option of going to a panel even before they know that there's real remediation at this facility. Third, it will be great if there's greater obligation from the government to consult with the stakeholders and particularly the petitioners when they are developing remediation actions, and to actually and of course they can disclose the result of the investigations without harming or putting in peril the workers. And the fourth, targeted adjustment, and we call these targeted adjustments because we think that it's just changing a part of the agreement, not like actually like something that will require a lot of work. Will be clarifying that a resolved during review outcome is a denial of rights determination for the three-strike system. But going into systemic improvements is something that would actually require more than just like changing something in the agreement. I will just announce that it will be good to add a substantive obligation requiring all USMCA parties to ensure employers bargaining in good faith. Mexican law currently doesn't have that explicitly, and it will be useful because in certain RRM cases that has been a limitation. Second, the Federal Center for Labor Conciliation and Registration, this new institution that was created by the 2019 reform, doesn't have a clear sanctioning authority. There is a bill in the Mexican Congress to provide that kind of authority. Having it in the trade agreement might support moving forward that bill. And third, if we really want to have a system that is transformational and that sets the stage for other potential regional agreements, it will be great if we could have a system that has an independent, neutral body that takes care of the investigation and that applies equally among the three countries. And here we draw some inspiration, for instance, of the US-Cambodia textiles agreement that was negotiated in 2004, where the ILO was recruited by the US government to take care of some of these monitoring functions. But let me stop there and we can go to the next part of our webinar.
Daniel, if you could please lead us into the discussion.
Happy to. So we have a stellar panel here that's gonna help us give us the experience of practitioners and labor experts both in Mexico and in the US of how the RRM has worked for different types of unions and actors, and also how it interacts with the labor reform in Mexico, which has been, as I said, a very important development. So with us, we have Captain Ángel Domínguez Catzín. He's the president of the Mexican College of Pilots. Welcome, Captain Domínguez. We have Jason Wade, the top advisor to the president of the United Auto Workers. Thank you for being with us, Jason. And we have Ben Davis, who is the International Affairs Director of the Steelworkers. As you see, we have a stellar panel of people with a lot of experience in the system. And I just want to start by asking each of you to share. All of you have been involved in this system as being petitioners, representing institutions that have been petitioners. So, what have been the lessons that you have learned through these cases, and what kind of reforms will you prioritize in the 2026 review to have a better tuned rapid response mechanism? Why don't we start with you, Jason?
Daniel and Lori, really appreciate all the work you guys put into this report. We look forward to having further conversations with you. We're also doing our own analysis, so I know I only have a brief amount of time here, but the UAW will be in the comment period, but also publicly putting out a deeper assessment of the rapid response mechanism. Kind of stepping back, labor and civil society has, how we see it, as approached labor violations internationally in 4 different buckets. You have like the global framework agreement or the standard setting approach, where unions might negotiate with a company. You have the due diligence process that you see really proliferating in Europe. And then you have the state to state. And then we have this new novel standalone mechanism, the rapid response mechanisms. We've been involved in all 4 of these, from Mercedes-Benz filing due diligence claims in Germany to trying to work through global framework agreements with German companies like Volkswagen and other suppliers. And by far, the rapid response mechanism is in a league of its own. The amount of how quickly it gives relief to workers is really, really exceptional. That being said, there's a lot of work still to be done. So it's the best game in town, but it needs to improve. Our observation, the UAW has been involved in multiple cases, either as a petitioner or in support of, in the case of like Catzín and Caterpillar, but also in supporting independent unions in Mexico, filers in the United States, but also reaching out to the USTR and the DOL and trying to intercede and give our opinion on how these cases should move forward and what we think would be the best remedy in these instances where workers have had their rights violated. I think the one thing to kind of recognize and appreciate, this is a political process that masquerades as a legal or judicial process. And that has made the mechanism sometimes very effective, but I think ultimately has put us in the spot we're in today. So where it's been positive is like in the early days when the USTR self-initiated around GM Salau, when it was unclear how this process would work. And I think Mexican workers were not fully informed of the process, and there was real tension there of whether or not this was going to work. That being said, as you go on, as Mexico was doing, arguably a Herculean effort of reforming its labor laws, there became a reservation that we saw within the U.S. government of, we don't want to push too hard. We want this to be successful. We don't want to push too hard. And there was concern of the USTR, the DOL, becoming Mexico's own Department of Labor, because during the transition from STPS to federal center, and even today, there's a lack of enforcement mechanisms, that there was a concern, which doesn't mean the labor violations or anything else has gone away. So to the concerns of workers on the shop floor, that is incredibly secondary, So I think there needs to be some rethinking of how this mechanism works. And we really appreciate, and we've been thinking about this, the independent fact-finding function. Underneath the NAFTA agreement, you had, kind of shaming documents that didn't cause any change in behavior of what was happening on the ground in Mexico. But still, that's an important piece. We are thinking through and want to explore the idea of a private right of action that actually disassociates the political considerations of the U.S. government, the Mexican government, the Canadian government, and really gets down to the brass tacks of what are the companies doing, how are what rights being denied. Also appreciate that it isn't only about companies violating workers' rights. We've seen in many cases where obviously, company unions have done the heavy lifting to violate workers' rights, and your note on judicial interference being part of the consideration. The issue isn't whether or not who did the violation. If the fact of the matter is workers are denied these rights and cannot democratically have input in the working conditions and wages of their facilities, that's where the harm is being done. Stepping back on procedural things, other things we would observe is, at least from the U.S. perspective, the labor attaches. One, there's 5 for the whole country. That is woefully understaffed. 2, they need substantially more authority, and then there has to be baked into that authority protections for workers and how they interact with those labor attaches. In the case of Catzín, we saw several workers get fired after talking to labor attaches, and them being fired for administrative discussions isn't protected by the rapid response mechanism. That is a huge fault in the system, and we need to have a way. Well, ideally, we want to have the Mexican government fully enforce the laws, but given that, the agreement ensures these rights within the agreement, labor attaches should be able to talk to workers inside the shop. They should be able to pull information from the employers. This is all stuff that we do to ensure that our customs and everything else are being fulfilled and their duties are being fulfilled. But when it comes to labor rights, we really, really clip these labor attaches' authority to do that work. I don't want to take up too much time in recognizing we only have an hour, but the only other thing I'll add is, one, we need to expand the rapid response mechanism to cover more labor violations. And secondly, we are fully supportive of a trilateral rapid response mechanism. You've touched on it, but there's an urgent need inside the United States. If our Mexican colleagues are unaware, in Texas, Mississippi, and Louisiana, workers today effectively have no rights underneath the National Labor Relations Act because they've deemed the National Labor Relations Board potentially unconstitutional. So if a worker was to file a ULP, a company would just have to say, I don't recognize your jurisdiction, and they have no remediation. And that's probably not going to be pushed through to the Supreme Court till late next year. So we fully welcome our brothers and sisters in Mexico pushing to increase our labor rights in the United States. So there's a lot more to be said, and we really appreciate the conversation. As we get into the review process, we'll be adding more to this. Thank you.
Thank you, Jason. And now let's go to Ben. Ben has been involved in several of these complaints, so I'm sure that you have a lot to say.
I will not say everything that I have to say. Thanks, and good morning to everyone, and thanks, Jason. That was a really good overview right there, to which I don't really have too much to add, but let me just highlight a couple of points in under two specific areas. One is the some of the specific fixes and I agree basically with all of the issues that Jason raised and the remedies that he put forward. A couple of other specific things that we've dealt with a lot are well, one is just the burden of proof on that you need to meet to bring one of these cases because you have to demonstrate that the product or service from the facility competes in the territory of a party with a product with the like product or service from the U.S. Sometimes that's obvious and not controversial, but in the case of mining, for example, and we had a case that actually went to a panel, and or on this issue. Uh, the it's very hard to tell once ore has been extracted from a gold mine or a silver mine or a coal mine and commingled with ore from other facilities. How do you trace back? So ore crosses the border into the U.S., it's traded, but there's no record. The U.S. government doesn't maintain a record of the place of origin. The Mexican government doesn't maintain a record. The employer has a record, but the employer doesn't have to produce that record because it's the petitioner's burden to show that that the facility is covered. So it's in some ways a small fix to simply say that the burden ought to be on the party that has the information to provide the information, but it would make an enormous amount of difference in this subset of cases. Mining is one of the very important export industries of Mexico's. We see it there. I think we'll see it in some other places as well. A second issue has to do, and we've seen this in many of the cases, is workers take their lives in their hands literally when they bring these cases, when they step up publicly against an employer dominated or employer allied union known as a protection union. And in a number of these cases, criminal elements are involved as a part of this equation, either with part of the union and or working with the employer. So there's been a lot of violence in the process, and workers have taken real risks. And many of these cases occur in remote areas of the country. We're not talking about downtown Mexico City or even downtown San Luis Potosí, a place where a lot of cases have happened. They're out in rural areas where both the cops and the narcos are around, and lots of times you don't know who actually committed the crime. So the issues of providing security have come up in a number of these cases. Sometimes workers have had to actually be evacuated and relocated to undisclosed locations. That takes resources, but what it really takes is the capacity of the Mexican government to protect workers who bring cases, because it's going to be hard to move forward if we don't get that. So those are a couple of specific issues that we've dealt with a lot. In the more general category, I think just the limited resources is a big issue. There to get this process started, both the Mexican government and the U.S. government put a significant amount of money in through the Department of Labor, through the USTR, particularly the Department of Labor, to provide assistance to unions in training and educating workers about their rights, and in covering the expenses of cases. The current administration has cut all that funding. There is no funding at this point. The Mexican government has also implemented an austerity budget, and they've cut the budget of their what they call their Federal Center for Labor Conciliation and Registration, which is an important part of the bureaucracy here, by a third in the last budget. So government resources and the labor movement is also providing solidarity, U.S., Canadian unions, but none of us are exactly flush right now. So money is a big problem. Lawyers, there are very few labor lawyers in Mexico working on the union side. It's not a very lucrative profession historically. I mean, there are for the big corporate unions, but to defend independent unions, there are literally a handful of lawyers who are bringing these cases, and they take physical risks and political risks as well when they are so identified with this movement. But there really has not been an investment in creating the next generation of labor lawyers to really build this out and expand it. Maybe labor lawyers from the U.S. will relocate to Mexico because there's more opportunity to do labor law there. But and don't get me wrong, the lawyers that are doing this are most of them are great. They've done an amazing job, but there's not nearly enough of them for this really to have an economic impact. So far, our calculation is about 60,000 workers have benefited have been involved in 67,000, I think. Workers have been involved worked at facilities where there's been a rapid response complaint. And about a third of those, maybe a bit more, have directly benefited with the things that Jason talked about. And I'm being told I don't have I'm being told I'm out of time. So I will stop.
Thank you, Ben. Let's turn to Captain Domínguez because the pilots union filed us a case against Mass Air, and I think it was a very successful case. So we would love to hear about your experience and also what you're seeing in terms of the review.
Thank you, Daniel. Thank you, everybody. It's an honor to be here. First of all, I want to thank Rethink Trade for the invitation and for the incredible work you guys are doing to put workers at the center of trade policy. Thank you very much. Thank you to Lori for your decades of tireless advocacy. You have opened for sure the doors of workers' voices, not only in the US, but also in Mexico. And for us to be part of this historic conversation, it's truly a win for us. So it's truly an honor to join you all guys today. And for sure, as petitioners under the rapid response mechanism in the Mass Air cargo case, we have seen both the extraordinary potential of the RRM and the structural barriers that still hold it back. When we, as ASPA, filed the petition in July of 2023, we alleged harassment, retaliation, and interference with freedom of association from the company. And the RRM worked as designed. The US and the Mexican governments moved swiftly. Mass Air reinstated a pilot with back pay. They issued the neutrality statement. They adopted these zero tolerance policies, created a hotline, and they oversaw a secret ballot union vote. We won that vote. And for the first time, the mechanism was applied in the services sector. This is truly historic for Mexico and for the agreement. And yes, we won the representation. We won the union representation. But there is still a reality, a hard reality. The company has continued to place cards to delay the formal registration of our collective bargaining agreement. So, while the RRM opened the door, the walk through that door has been slowed by appeals, legal maneuvers, and judicial bottlenecks. That is what we believe must change. The mechanism is fast, but the domestic structures are still too slow. and the justice delayed becomes justice denied, as we all know. So that is why, based on our short experience, we believe that the USMCA reviews must focus on some urgent reforms. First, expedite the enforcement. Cases, we believe, must have strict judicial timelines, 30 to 60 days maximum, with penalties of obstruction. Workers cannot wait years to see the benefit of rights already recognized. Enforceable collective bargaining. Winning the representation is not enough if employer can stall it forever. The RRM must require good faith bargaining after recognition with binding timelines for contract registration. Independent verification and transparency. Government should not close cases on paperwork alone. Independent expert must inspect, verify, and for sure publish and the outcomes openly. To expanded coverage. I mean, Master proved that RRM is not just for auto plants. It must extend to agriculture, services, and all other labor industries in all three countries. And beyond these points, we believe here in ASPA and at the Board of Pilots, we must go further. We can and we must expand its scope, and to include not only the freedom of association, but also other fundamental rights recognized by the island. So, in short, I don't want to take more time because Ben and Jason has already been incredible explaining this morning. But in short, we believe that Master have showed us that the RRM can break through, but unless it's faster, it's stronger, and backed by real accountability, victory's risk being only symbolic. So we should do not, we cannot only celebrate representation won, only to see that the collective bargaining is indefinitely delayed. If we make these reforms, the RRM would not only protect the Mexican workers, but we believe that it will strengthen the entire North American labor model, ensuring that trade and justice move together.
Thank you so much, Captain. I think that that's one of the things that also we found in our study, that there has been a lot of progress in representation, but when we get to the moment of collective bargaining, rights are covered by the RRM. So we should see more progress in that regard. And before allowing the audience to ask a couple of questions to our live speakers, I think that we have two interventions. So I'm going to turn it over to Lori.
Gentlemen, all of you, thank you for really inspiring and fascinating, powerful interventions and for all of your great work. We hopefully have overcome our audio problems.
Hello, this is Congresswoman Rosa DeLauro, and I am glad to say a few words about the release of this groundbreaking report, the results of months of hard work, data collection, and analysis by researchers at Rethink Trade. Congratulations. I have been eagerly awaiting this data because I fought hard for the USMCA agreement to be different from our trade deals of the past, which drove a race to the bottom and sold out American workers by looking the other way when other countries cheated to drive down prices by allowing union busting or paying workers poverty wages. The rapid response mechanism was a giant leap forward for how we enforce the rules of our trade agreements and improve labor conditions in partner nations. By moving from a state versus state model to a facility-specific model, we improved accountability and helped address some of the most egregious cases of labor rights violations. And critically, we were able to do so swiftly while the problem could still be addressed. And there are success stories to tell. Across more than 30 cases that were concluded thus far, the RRM has been used to deliver wins for workers, such as reinstatements after retaliatory firings, improving organizing opportunities for independent unions, and stronger contracts that protect workers. But like any first-time policy, there are also limitations. Employers have found ways to avoid playing by the rules, and the statutory review of the USMCA, which is now getting underway, presents a critical opportunity to revisit and revamp the rapid response mechanism to ensure that it can accomplish what we intended it to do. We need good data to make good policy, and that is what this report will help us achieve. I am grateful to all of the researchers and advocates involved in this project, and I urge you to keep up the good work. We must continue to focus on improving our trade rules so American workers and businesses can participate in the global marketplace on a level playing field. I will continue to fight in the Congress for better trade deals for working people, and research reports like this one. You are a critical tool for the fight ahead. Thank you.
Thank you to Congresswoman DeLauro. And we also have the honor of hearing from Roxanne Brown, who is the Vice President at Large at the United Steelworkers. The Steelworkers and UAW have done yeoman's work amongst American labor unions, helping, as Jason said, do support for these cases, litigate these cases, advocate with the U.S. government for these cases. And so Roxanne Brown, an officer of the Steelworkers, who wanted to be with us but had a scheduling conflict, has sent us this video.
Thank you for the opportunity to speak with you today, and thank you to everyone who's made it their mission to fight for fair trade. It's undeniable that the North American Free Trade Agreement, or NAFTA, was disastrous for American workers, costing hundreds of thousands of good, family-sustaining jobs and hollowing out countless communities. Our union was among the first to sound the alarm about the deal, and we worked diligently for decades to mitigate the damage to our domestic manufacturing and our members' livelihoods. And when efforts to renegotiate the agreement took place, we worked to help reform it to ensure fairness for workers across all three countries. We understood, as well as anyone, what was at stake as the first Trump administration sought to renegotiate the deal. We understood that in reshaping the agreement, there was an opportunity to protect good jobs, preserve our environment, expand workers' rights, and ensure a more level playing field for generations to come. And thanks largely to the efforts of labor and Democrats in Congress, the USMCA did make some progress toward these goals. Arguably, one of the most significant changes was the institution of a rapid response mechanism, which helps enforce workers' rights in Mexico. I don't think I need to tell any of you how badly the harsh repression of democratic unions in Mexico, the imprisonment and even murder of union organizers, hurts workers across North America, driving down wages and undercutting working conditions in a race to the bottom. The rapid response mechanism was a new tool to help remedy a corrupt system dominated by corporations that attempt to silence workers' voices. The mechanism allows any interested party to petition for a case. It also expedites enforcement of collective bargaining rights, and it allows for targeted penalties. As a facility-specific mechanism, it allows for action against the direct violators. All of this is incredibly important, but it's not enough. This mechanism alone has not been able to ensure that Mexican workers have widespread access to true union representation, and it's nowhere near enough to address the continuing threats to the jobs and living standards of American workers. Rapid response cases take about a year to resolve, and while that's a lot faster than any other trade mechanisms, it's a long time for Mexican workers who in most cases have been fired and often face blacklisting, threats, and violence while the case is being resolved. On top of this, there's the problem of scale. Only 38 rapid response cases have been filed, and only about 20,000 of Mexico's 10 million manufacturing workers have seen real benefits like a democratic union, a contract, or a significant wage increase. While this is better than nothing, and we celebrate what it's done for these workers and their families, it's simply too little to close the 10-to-1 wage gap between U.S. and Mexican manufacturing workers, a gap that continues to drag down wages and incentivize outsourcing. The rapid response mechanism was also intended to go hand in hand with a serious effort by the government of Mexico to fully implement its labor rights commitments. The government has not done its part. In the meantime, China, Vietnam, and other low-wage countries continue to use Mexico as a platform to access the U.S. market. And, of course, U.S. companies continue to outsource production and work to Mexico, abandoning domestic workers and communities. So what does this mean for workers? It means we need to keep fighting, keep pressuring governments across the United States, Canada, and Mexico to back democratic unions, not just in Mexico, but across North America. It means that we need to stand in solidarity with our counterparts in other countries, recognizing that the problem is not workers themselves, but a broken system seeking to exploit us all. And we need to encourage the Trump administration to put its money where its mouth is, not simply talking about fair trade, but restoring funding for vital programs that assisted Mexican workers seeking free and fair union elections. Done right, the USMCA could still arrest the trend of pitting workers against each other in a race to the bottom, and help improve standards for workers across North America. Yet as we look to the future, it's clear that the USMCA still needs a great deal of work before it will truly deliver for working families.
Thank you very much to Roxanne Brown for that presentation. And we still have a few minutes. We do not have a bunch of questions in the question and answer. So if you want to pop one in there quickly, but I'm going to take the chair's prerogative to ask for a lightning round of our four panelists to ask overarching question in sum. So we leave everyone with these inspiring thoughts. With the 6-year review coming up, it started. What is, in your view, in short, the goal of what we want at the end of that process as far as what we want the RRM to deliver? And then what are the one or two most immediate things that must happen in order for that to be a success? So for instance, what I would say is more collective bargaining agreements with higher wages and a speedy time and less continuing abuse of workers. And to do that, the changes that we lay out in our report, plus the good ideas everyone else has suggested.
I think getting the rapid response mechanism to actually function at a higher level and or have the Mexican government fully implement the labor reforms. But I think there's as Roxanne directed at, there's a ramping up problem. And, Mexican workers' wages have been suppressed for decades. And even if we had 1,000 rapid response cases, and even if people went into bargaining and fought as hard as they could, it will not happen fast enough. And that's why the UAW is advocating for a sectoral minimum wage that actually short circuits some of that work. We can't make workers whole for all the years of work they were paid substandard wages, but we can take corrective actions today to start to have the wealth that they produce for these companies reflected in their paycheck. There is a pathway. If you recall, NAFTA was supposed to raise wages in Mexico, create a middle class, create demand for U.S. goods. There's a way to do that. It is not the invisible hand. It is policy, and it is stating it correctly and saying these jobs should create family sustaining wages and lift up workers in all countries. So there's enough for everyone.
Thank you, Jason. Well said.
Look, the wage gap between manufacturing workers in Mexico and the US was 10 to 1 in 2019 when this process began to be implemented. And today it's 10 to 1. That is not to belittle at all a huge amount of work that's been undertaken by Mexican workers, first of all, but also the Mexican government, the U.S. government, a lot of people in USTR and the Department of Labor, members of Congress, and all the unions at this table and a bunch that aren't. But we have to deal with realities, and the reality is that all those efforts haven't actually changed the reality on the ground in any significant way for the Mexican working class or for workers in the U.S. who are affected by this, because why do people move production from the U.S. to Mexico? Because they can pay 10% the wages, and the mechanism has had some impact in some places and probably a demonstration effect on top of that, but it has not actually changed the reality. And so we have to change that reality, I think. And every single suggestion that's been made here, and there will be other reports and other suggestions, and we should take all of that together. Of course, the current administration in the U.S. is also trying to shrink the wage gap, but they're doing it mostly by reducing wages in the U.S., and that will close the gap. That is not our solution. We're not talking about lowering American workers' wages or Canadian workers' wages to improve the. We're talking about lifting up workers who work just as hard as we do, under the same conditions or worse conditions, and they just get paid a lot less for it. So that's what has to change.
And just to reflect for people, you will find this fact in the study, which you can pick up off our website, rethinktrade.org. That's rethinktrade.org, that Mexican wages today remain lower than wages in China. And if you don't believe that, there's a footnote on that. That is a true fact. Captain Domínguez, may I ask you to contribute next?
Yep. I feel that the final goal for 2026, my Santa Claus letter would be to transform the RRM from an emergency tool into a permanent guarantee of labor justice across all North America. In other words, I think that the RRM should no longer be seen only as a mechanism that only fixes extreme violations in a few factories, and it should evolve into a system that delivers justice without delay, as I was saying earlier, covers all workers also, not only, including services, agriculture, and in terms of soccer, speaking of the next World Cup, I think that we must level the playing field by converging on fair wages and responsible working hours. In Mexico, we have this discussion for almost long enough that I can't remember, including to move forward to a 40 hours work week. We in Mexico, we still have this 48 in paper, because actually workers in Mexico, sometimes they work even 50, 54 hours a week. And the RRM can stop the race to the bottom and create a race to the top for all workers, not only Mexico, the US, and Canada.
Thank you very much. And I am going to then have Daniel close us out and end the webinar with his contribution.
Thank you, Lori, and thank you for joining us, to our speakers. I think that this was a fascinating panel. I will just say that as someone who has been working in trade policy for several years now, finding this kind of tool that really breaks the logic of trade agreements that gave so many privileges to corporations without any kind of responsibility was really refreshing, and it's certainly a need. And for the 2026 review, what we need is to build on top of that progress that was made in 2019, try to find where to fine-tune the mechanism, but really take it to the next level. And I love what Captain Domínguez had to say, that kind of permanent guarantee of justice. That's what we need in order to make of North America this high road model of economic integration that could be inspiring for many other regions. So I will finish at that, and thank you all for joining us.
Thank you, Danielle, for the report. Everyone, again, you can see at rethinktrade.org a copy of the study. This video, there's a video of this presentation as well. Thank you so much, panelists. Thank you, everyone who is with us. And with that, I will end the webinar. Thank you, everyone.